And do you want to do your introduction, Alex?
Yes, sir. Welcome, everybody. Thank you for being here with us tonight. We're going to go ahead and get started to respect the time of our presenters today. Just to let you know, if you know anybody who is going to come in late or who is going to miss today's live webinar, it is being recorded and it will be made available through the library's Facebook and YouTube and through Alpine Legal Services resources as well. Today we are with Alpine Legal Services and with Natasha from Towards Justice, I always switch it around. And we're very happy to present this program as the library. Just a couple of things before we get into our presentation. We do have a chat option. Feel free to use the chat if you have any quick questions, comments, or any technical issues. I will be watching that chat to be able to help you with those. We also have a Q&A. That is the bubble chat option on your Zoom screen. This is where we want you to ask any questions for the presenters or for the facilitators. These questions will be saved there for a good time for them to answer. The last thing about our webinar today is that it is being recorded and it is being offered in Spanish and in English simultaneously. If you look at the bottom right of your Zoom menu, you're going to see a gridded globe icon. Go ahead and click on that globe and choose the language of your choosing. You can choose Spanish or English, or you can simply choose to turn it off. If you have any issues with the audio, make sure you click on mute original audio. Again, if you have any questions or any issues with the technical aspects of the Zoom webinar, please let me know on the chat and we'll get you going as soon as we can. And with all of that, I will turn it over to Tony.
Good evening, everyone. My name is Tony Mendez. I'm a staff attorney with the nonprofit Alpine Legal Services. We work from the region of Aspen to Parachute, Colorado on a variety of different civil service matters. We decided to do a series of Know Your Rights events for 2022. And this event today is the event that will kick off our series. Tonight, we have Natasha Viteri, who's an attorney with Towards Justice, who will be presenting on labor law, Know Your Rights topic. I would like to take a minute just to thank our sponsors for this event. And those sponsors are Colorado Mountain College, the Garfield County Libraries, Towards Justice, and Alpine Legal Services. Without further ado, I'd like to introduce Natasha Viteri. Thanks.
Thanks so much, Tony. Can you hear me? Everyone? Okay. Awesome. So, hi, everyone. My name is Natasha Viteri. I'm an attorney at Towards Justice, as Tony said. I'll be doing the Know Your Rights presentation tonight. So let me go ahead and share my screen so we can kick this off. All right. Please let me know if there's any issues or if you can't see it. So as I said, welcome. Thank you all so much for being here. Thank you to Alpine Legal Services and Colorado Mountain College and Garfield County Libraries for hosting this. This is so important. We're really happy that you chose to spend your Monday night with us. So thank you all. As I said, my name is Natasha Viteri and I'm an attorney at Towards Justice. Before we go into who Towards Justice is and what we do, I would like to learn a little bit more about who's here tonight. So if you can, in the chat, you can introduce yourself. You can tell me, if you're representing an organization, you can tell me what organization you're representing. If you're a worker, you can tell me what industry you work in, if you don't want to give me more details. This will help me guide my presentation a little bit, and I might be able to focus a little bit more on what might matter most to you as an audience. So feel free to do that. My colleague, Nina, who's amazing, is monitoring the chat too, so she can jump in with anything that I'm missing from there. Great. So for those who don't know who Towards Justice is, we are a Denver-based nonprofit legal organization that advocates for and collaborates with workers and workers' organizations to build worker power and advance economic justice. So the most important thing that I want you to know is that we're here because we cannot do this work without your voices and without your experiences. We're really passionate about going after bad employers, and we really exist to carry cases forward that can make an impact in the lives of our clients, in the lives of their coworkers, and basically their industries, right? We hope that after this presentation, you'll know a little bit more about us and how we can combat workplace injustices And ultimately, we want to make sure that you feel comfortable reaching out to us with any employment-related questions you may have. The most important thing here too is we believe that workers have power, and we want to show you how to defend it. All right, so as I said, here at Towards Justice, we're here to help, and we want to make sure that workers feel comfortable reaching out. We are lawyers, and we do litigate our cases mostly in federal court, and we really like to focus on impact litigation, and that basically means litigation or cases that's going to affect a lot of different workers at once. However, though, we also run a pretty robust intake program, and this intake program is really special to us, and it's important because this is how we find out what the labor landscape is like. This is how we find out what labor abuses are occurring in the real world. So again, y'all are our connection to what's happening on the ground. So if you remember one thing from tonight's presentation, just remember that at Towards Justice, we offer free and confidential intakes. So all you have to do is go on our website and fill out an intake form. And these are available in both Spanish and English. And there you can tell us what's going on, and we'll reach out to you with resources. As I said, we're lawyers, but unfortunately, we can't take every case that comes through our doors, but we can either point you in the right direction, or we can refer your case to one of our really amazing employment attorneys that are in our network. Also want to make sure that people understand your immigration status does not matter to us when you come for an intake. In fact, we can help you direct you to the right resources or explain your rights as an undocumented worker. So please reach out. We also have Spanish-speaking attorneys like myself, so please, contact us. And something else I want to kind of highlight is if you have a really specific question about your employment situation or about an employment issue, fill out an intake form, because that will give me enough detail to kind of get back to you. A question during the presentation about your very specific issue might not be as helpful to you, so keep that in mind. All right, so I could be here all night if we wanted to cover all of the topics that are relevant to workers' rights. However, we decided to just choose a few topics for tonight that we thought were really relevant for tonight's presentation. So for this presentation, we're going to be covering workplace health and safety, paid and unpaid leave, and ways to build and defend worker power. I also want to plug our presentation that's coming up in April. So we are doing a second part to this presentation, and that will be on April 20th. And we're going to cover other issues that are also really important. And those will be more related to wage theft and recovering unpaid wages, discrimination and harassment. And we're going to also review other ways in which employers undermine workers' abilities to leave their jobs. So we'll talk about things like non-competes, non-poaching agreements, debt bondage, coercion, human trafficking. So we'll talk about a lot of different things in April, but I want to make sure that people have it on their calendar. So if you couldn't join us today and you're watching the recording, make sure to join us on April 20th too. All right, so as many of you know, employers frequently exploit the reduced bargaining power of immigrant workers and guest workers. And they do that to deny them fair pay, to treat them worse than other employees, to deny them dignity in the workplace. And these practices definitely harm undocumented workers who are victims of labor abuses, but are too scared to come forward. So we want to make sure that y'all know that Towards Justice really supports immigrants and guest workers, and we want to do what we can to challenge these systemic abuses. I also want to highlight this because a lot of the protections that I'll talk about in today's presentation also apply to employees, which can include undocumented workers. So make sure that you kind of pay attention to that, because if you are an undocumented worker, a lot of these protections can still apply to you. Okay, so let's jump right in and talk about the topic of the hour. So one of the most important and pressing issues that we have seen in our intakes that workers talk about is COVID-19. So since the pandemic began, a lot of employees have told us that they're concerned with workplace safety and specifically how COVID affects their job. So I want y'all to ask yourself a few questions. How's your job been affected by COVID-19? Are you working remotely? Do you have to go into your job? And also ask yourself, do you feel safe at work? Has your job implemented precautions against COVID-19? Can you safely distance from other employees? Can you distance from other customers that come in? So for example, something that comes to mind for me is someone who works at a meatpacking plant, for example. So they might be put on the line and not be able to distance safely because their bosses and the company that they work for is prioritizing productivity over safety. So they're not allowed to spread apart. and they have to keep that meet going at the same rate. So if you work in a place like that, you might not feel safe at work. And also think about what happens if you get sick. COVID-19 has really ripped through a lot of our communities. It's possible that many of you have already gotten COVID, or that you know someone who's already had COVID. So did your employer explain what kind of leave is available to you that you can take if you do get COVID? And for how long? Did they tell you if you were going to be paid for this leave? So lots of those questions come up too. And lastly, what if you don't feel safe at work? Do you feel like you can talk to your boss about it? Do you feel like you're going to get in trouble for speaking up? So again, all of these things are really important considerations when it comes to workplace safety. And of course, COVID-19 has done a great job of highlighting the disparities in power and wealth, with really harsh impacts on immigrants and people of color. So since the pandemic began, workers across lots of different industries have had trouble accessing paid leave. They've had trouble reporting workplace safety issues, and their employers have done a good job of kind of crushing employee organizing. So whether you're trying to figure out how to follow public health recommendations after you've been exposed to COVID, or if you're trying to return to work after getting COVID, every worker should know what rights they have and be able to enforce them. So if you have a particular situation that's special to you, please submit an intake test and we'll be able to help you out. Great, so did you know? A few things that are important to remember about COVID are on this slide, and I will expand on these points kind of one by one, but I want to make sure that we're all on the same page first. So first, did you know that we are still in a public health emergency? So this is a little confusing because there's lots of contradicting information and a lot of people don't really know what's going on, but we are in a public health emergency until at least February 13th, 2022. I know that doesn't sound like a lot of time because that is, I think, next week already. But this is important because being in a public health emergency is going to affect the kind of leave that you can take from your job. And it's also going to dictate what kind of resources are available to you. Another thing I want to mention, if you haven't gotten your vaccine yet, and that might be for many reasons, but maybe you're concerned about missing work if you feel sick afterwards, know that your employers must offer time off for workers to get vaccinated. And they also have to provide time off if you have any sort of vaccine side effects. So if you're feeling really sick, if you're feeling, the headaches and all of those kinds of symptoms that prevent you from working, you can take time off. So get your vaccine if you can, and especially try to do it before the end of the public health emergency that's coming right around the corner. And also super, super important as it relates to COVID-19, you cannot get fired if you get sick. So if you get sick of COVID and you don't go to work and your boss fires you, that's prohibited. They cannot do that. And I'll talk a little bit more about this in a little bit. And then lastly, there's a really good chance that you might have some type of paid leave and a very, very good chance that you have unpaid leave if you get COVID. And again, I'll discuss this in the next couple of slides. All right, so let's talk about leave. As of January 1st of this year, all Colorado employers, regardless of size, are subject to traditional paid sick leave requirements. And that's because of this new law called the Healthy Families and Workplaces Act. That's a mouthful. I'm just going to call it HFWA from now on. So again, Healthy Families and Workplaces Act is HFWA. As I said before, we are still in a public health emergency until mid-February. And HFWA is going to provide two different types of leave. All right, and I'll talk about each in the next slides. But one type of leave that it provides is accrued leave, and the other is public health emergency leave. Also important to note is that HFWA protects undocumented workers as well. So even if you don't have status, you can still take advantage of this leave. Okay. So as I said, at the beginning of this year, no employer was exempt. So it doesn't matter if you're big or small, if you're public or private. The only exception is the federal government because this is a state law. So any other employer is not exempt and they must provide this kind of leave. And no employees are exempt either, except for railroad employees, certain types. So that's a kind of a strange exception, probably doesn't apply to a lot of you. But just know that as of the beginning of this year, no employers and no employees are exempt except the ones I mentioned. An employee is going to begin accruing leave, and you're going to accrue that at 1 hour of paid sick leave for every 30 hours worked. up to a maximum of 48 hours. So accrued leave is special because you have to earn it basically, right? So you work 30 hours and you get 1 hour of accrued leave, and you get 48 hours of it. You can accrue up to 48 hours, which basically is 6 days of leave. One thing that I also want to highlight is that if you've been working for an employer that has more than 16 employees, you could take advantage of this last year as well. That went into effect January 1st, 2021. A couple fun things about accrued leave. You're going to use it as it is accrued, so you don't have to wait until a certain amount of hours are collected. You can use it as you collect it, as you get it, and you can carry it forward and use it in a following year, in a subsequent year, if you don't use it in that same year. So a lot of people have PTO that already kind of works like that, but this is going to be special for people who don't have access to that. And speaking of already having PTO, an important kind of caveat here, and something that I want to call to your attention, is that if you work at a place that already has a more generous PTO policy, so if their vacation and sick leave and paid time off policy is already good, and that basically means at least 48 hours of sick leave. So if your employer's already giving that to you, you're not going to get additional leave. So think of HFWA accrued leave as kind of like the basement or the floor. So your boss can go above it, but they can't go below it. So important to keep that in mind. And you can use that immediately. And this is also available to part-time employees. So of course, part-time employees are going to accrue this or collect this a little slower, but they can also use it. And last thing about the PTO policy for your job. So if they're going to use their PTO policy and not the HFWA one, then they have to let you know that that's what's happening. So they have to let you know that their PTO policy meets the requirements of HFWA. Okay. So now that we kind of know how much you can get, what can you use this for? Employees can use accrued HFWA leave for to be absent from work for lots of different reasons. So first, if you as the employee, if you have a mental or physical illness, an injury, or a health condition, if you're looking for a medical diagnosis, or if you need care or treatment for that medical diagnosis, and even if you need to obtain preventive health care, so if you have to go in for your pap smear or for your physical every year, those are different types of things that you can use HFWA leave for, okay? Also, if you as an employee have to care for a family member that has all of the things that I talked about before. So if you need to care for someone who has a mental or physical illness, an injury or health condition, if they need a medical diagnosis or care or treatment, or if they need preventive health care, then that's also something you can use your leave for. Also, if you or a family member have been the victim of domestic violence, sexual assault or harassment, and you need time off to be able to deal with that, then that's also going to be something you can use HFWA leave for. And then lastly, if during a public health emergency, a public official has ordered your child's school to close or their daycare or your place of business, then you can also use HFWA leave for that too. All right, so as I said, there's two types of HFWA leave. We talked about accrued paid sick leave, and then now we're going to talk about the public health emergency one. So that also went into effect January 1st, 2021. And under state law, all Colorado employers must provide 80 hours of supplemental paid public health leave if there's a federal, state, or local declaration of emergency. So as I said, we're still in one, so this still applies. And you can use 80 hours, and that means basically 2 weeks. So you can take 2 weeks off if you have COVID or if you're dealing with COVID, and that must be paid. So what can you use this for? If you're self-isolating due to an exposure, so let's say that you are at work and your coworker texted you that they were positive for COVID and you have workstations that are next to each other, then you can take that public health emergency leave. If you have symptoms, so if you're already feeling like this may be COVID, I don't want to infect my coworkers, then that's another reason. Or if you need to get a diagnosis, so you have to go get a COVID test or something like that. If you're not able to work due to a health condition that may increase your susceptibility to risk of illness, or if you're caring for a child or other family in all of those categories, and if their school is unavailable because of the public health emergency, then you can use this public health emergency leave to be able to justify and get paid for that absence of work. Something that's really important to keep in mind though, and this has been kind of an issue that the Department of Labor wants to clear up, public health emergency leave is a one-time thing. So if you got COVID in 2021 and you use your 2 weeks, you're not going to get more in 2022. So this is a one-time thing. If you do have to use it again, if you do get COVID again, then you can take additional COVID-19 leave unpaid, or you can use your accrued leave as well that we talked about before. Important to note, for public health emergency leave, there's no documentation requirement for an employee to take this leave. So, you don't have to present that positive or negative test. They can't ask for a doctor's note or anything like that. And that's different from accrued leave, where they can ask for documentation if you're gone for more than 4 days. So I'm going to talk about that in a second as well. All right. So did you know, which I hope you do now, that there's 2 types of FFWA leave, right? The public health emergency leave and the accrued leave. For both types of leave, it must be paid for time on leave. And it's going to be paid at the same pay rate the employee earns during their time worked. As I said before, it cannot be counted against you as an absence that may lead to firing or other negative action. And when I say other negative action, it doesn't only mean getting demoted or getting your hours cut or anything like that. It can mean a lot of different things. So if you're being treated differently in a negative way after, maybe taking this kind of leave, then that can be a situation where you're being retaliated against, which I'll talk about in a second. As I said, employers can require documentation for paid sick leave for the accrued kind, but only if you're gone for more than 4 days. And that has to be consecutive. So if you're gone for 4 days straight, they can ask for something. If you're taking public health leave, they cannot. And as I said, and as I hinted at before, you do have lots of rights under HFWA, and one of them is that your boss can't retaliate or interfere with those rights. So as I said before, it doesn't only mean being fired. Your boss cannot require you to find a replacement worker or job coverage if you're taking paid leave. So we've heard from lots of employees that they'll call in and say, I got COVID, and their boss says, that's fine, just find someone to cover your shift. They cannot do that. You're sick, you have to deal with your sickness, and your boss is going to be the one that has to take care of that. As I said, an employer cannot fire, threaten, or otherwise retaliate against or interfere with use of leave by an employee. So if you're requesting or taking HFWA leave, and even if you're informing or telling other employees how to take HFWA leave, if you file a HFWA complaint, or if you're cooperating with a HFWA violation investigation, those are all going to be protected actions, and your employer cannot come after you for that. All right, so let's say that after all that, and you complain to your boss about feeling unsafe at work and all of that, and let's say that your boss fires you. So let's take the example that I talked about before with the meatpacking plant. So you're not able to social distance, you feel like you've been exposed, you want to take leave, or you want to do different things, and your boss says no. So can they fire you for speaking out about feeling unsafe at work? And the answer to that is no. So under the Public Health Emergency Whistleblower Law, again, a big name for a law, we're just going to call it the FEW Act. So under the FEW Act, an employer cannot retaliate against you for raising reasonable concerns about a workplace's threats to your health or safety, including by firing you or changing your schedule. So we've heard, again, that maybe the employee didn't get fired, but they messed with this person's schedule. That's a form of retaliation, so that's not going to be allowed. This law also applies to employees working as independent contractors and those who are undocumented. So again, undocumented workers can seek these protections. And in addition, this law isn't only protecting you talking to your boss about feeling unsafe, it's also going to protect you if you decide to go to a government agency. So let's say that you want to go to the Colorado Department of Labor and Employment and complain about a FEW Act violation, or if you decide to go to OSHA or something like that. All of those are going to be protected as well, and the public. So if you decide to speak out about this with the media or something like that, then that's going to also be protected. Okay. All right, so I wanted to put this on your radar, not because you're going to deal with this anytime soon, but a new kind of leave is coming in 2024. So Colorado voters approved Proposition 118 in November of 2020. I'm not sure if y'all remember that being on the ballot, but this proposition basically paved the way for a state-run paid family and medical leave insurance program. Big name, we're just going to call it the FAMLI program, as you can see on the slide. Basically, the FAMLI program will ensure that all Colorado workers will have access to paid leave in order to take care of themselves or to take care of their family during life circumstances that might pull them away from work. So if you're growing your family, if you're taking care of a loved one with a serious health condition, and I'll talk about the other examples. But you might not have heard about this because FAMLI hasn't started yet. They're going to start providing benefits through this program starting on January 1st, 2024. And both employers and employees will contribute premiums for this program starting on January 1st, 2023. So you don't have to worry about this year, but starting on January next year, you might start seeing deductions, and then you can start using this leave in 2024. As you can see here, this FAMLI program is going to provide up to 12 weeks of paid leave, which is awesome. That's basically what, three months of paid leave to take care of yourself or your family if you're going through kind of like a big life change. So what can you use this for? Let's say that you are having a baby. If you're going to adopt or foster a child, those count. If you're caring for yourself, if you have a serious health condition, if you're caring for someone else that has a serious health condition in your family, if you're making arrangements for a family member's military deployment, or, and this came up in other laws that we've talked about already, but if you're addressing the immediate safety needs or impacts after domestic violence or sexual assault, then you can also use FAMLI leave. People who experience pregnancy or childbirth complications can receive an additional 4 weeks. So that can be up to 4 months of paid leave if you have those kind of complications. So again, keep this on your radar. It's coming up. It's not relevant right now, but it's something that you might want to take advantage of in the future. All right. So now you know what to do if you get COVID-19 and if you have to take time off. But how else can you defend your power as a worker? What kinds of things will ensure that you and your coworkers have leverage and are able to demand fair treatment from your employer? What kinds of things would kind of help that? So I really like this slide. I like the colors, but I want to encourage everyone to join together like worker bees. So as you can see, worker bees, if you think of them, it's all about collaboration. It's all about what's doing best for the hive and kind of working together. So I want to make sure that workers understand that the biggest thing that you can do in order to challenge your employer is to join together as a team. So think about King Soopers, for example. I'm not sure if y'all, saw King Soopers employees picketing outside of the different King Soopers and kind of working together. So again, we saw them organizing and demanding better wages and conditions, and we want to be like them. We can see what happens when you join together and demand the action. So I was reading a little bit about what happened after the strike, and basically they negotiated a contract with wage increases, better healthcare, more stringent safety protocols, and these will all apply to about 78 stores around the Denver metro area. So again, that's an awesome example of teamwork, and this is something that we really want to encourage workers to do. And something that I also want to make sure that you understand is that you do not have to be in a union to be able to be protected and work together as a group. So let's talk about what that means. All right, so did you know that you and your coworkers can talk openly about your pay? All right, I know this is the kind of a sensitive subject because people don't like talking about money, but to be honest, at the end of the day, everyone is helped when you talk about your salaries. So talking about your pay doesn't only talk about how much you make per hour, or per piece, or by commission, or all of those things. It can include wages, salary, and bonuses as well. So those are things that can be compared to. And it is illegal for your employer to retaliate against you for standing up with your coworkers for better treatment. So again, they cannot come after you if you decide to band together. And what I said before, you do not need to be part of a union to be protected. That's a big misconception. You can engage in this concerted activity with other employees and not be part of a union. And even if you never want to be part of a union, that's fine too. Okay, so as I said, worker bees band together, and when you work together with other employees, that is called protected concerted activity. The National Labor Relations Act, so another long name, I'm just going to call it the NLRA. So the NLRA grants employees the right to engage in protected concerted activity, and any discrimination based on that activity is prohibited. So you have the right to act with coworkers to address all sorts of different types of work-related issues in lots of different ways. So what does this look like, right? It's not only about picketing like the bees are doing on the side. It can mean talking with coworkers about wages, benefits, or working conditions. It can mean circulating a petition asking for better hours. You can participate in a refusal, so a concerted refusal to work in unsafe conditions. So if you want to walk out, that's something that's also going to be protected. Or if you join with coworkers to talk directly to your employer, to a government agency, or to the media about your problems. So those are all going to be protected activities. So again, federal law protects employees engaged in union activity, but that's not all. Even if you're not represented by a union, even if you have zero interest in having a union, the NLRA will protect your rights to band together and improve your lives at work. Okay. And something else that I think is important to remember about concerted activity is that it doesn't always have to take place in a group. So a single employee may also engage in protected concerted activity if he or she is acting on the authority of other employees. So if they're bringing group complaints to the employer's attention, if they're trying to induce group action, if they're trying to get people to work together, or if they're trying to prepare for group action, then that can also count as protected concerted activity. So what do you do if you think an employer has violated your right to engage in this kind of protected activity? What you can do is you can file a complaint with the National Labor Relations Board. So that's the NLRB. And the NLRB is an independent federal agency that works to protect the rights of private sector employees to join together, with or without a union, to improve wages and working conditions. Another thing that I want to highlight is that contacting and getting assistance from the NLRB is completely free and confidential. So just like our intakes, free and confidential. They will not disclose any information to your employer unless you decide to file a formal complaint. Also, it's illegal for your employer to fire, demote, harass, or otherwise retaliate against you for filing a complaint with the NLRB. So again, you're protected in doing that group activity, and you're also protected if you complain about your employer kind of interfering with that activity. So what I want you to take from this is that you can talk to your coworkers about your pay. You can talk to them about your work conditions and about anything else that affects your lives at work. So talk, communicate, share stories, and that really, that's one of the biggest ways to improve your lives at work. All right, so I got through that a little quicker than I expected, but I want to see what questions there are. As I said, if they're super, super specific, I think it would be much more beneficial if you submitted an intake for a website, and then we can get back to you with like advice, pointing you in the right direction, a referral, and things like that. But I will let's see. I can look at the chat in a second if I stop sharing. And then here, I also just wanted to put our website up one more time. So that is the link that you'll use if you want to submit an intake. So I'll go ahead and stop sharing so that I can see the chat. All right, I see that Nina's been answering some questions, which is awesome. And there's a lot of chat. If anyone has like a specific question that they want to speak, then go for it. But if not, I'll just take my time to read the chat real quick.
And we do have questions coming in through the chat.
Oh, perfect. Awesome. Okay, sorry, I'm like still scrolling through that. Okay, so we have one question there. Difference between FMLA and HFWA, that's a great question. As far as I know, FMLA is unpaid. So you can take that and you can, but that won't give you a paycheck. That won't kind of replace the income that you would lose from working. HFWA is paid. So that's something to keep in mind. Thank you for that question. And again, no worries if there's not a ton now. I know I threw a lot of information at y'all. Leave is not the sexiest topic, but it is important that everyone understand what rights they have with COVID, since that might be something that, again, is going to stick around for a while. So we want to make sure that we know what options are available. But anything more specific, definitely please go to our website, submit an intake. We typically look at those on Monday. So if you would like an employment issue resolved or at least some advice on it, then I would submit it, this week before Monday so that you can get an answer a little quicker. I know Nina's been answering a lot of these questions in the chat, so thank you, Nina. I appreciate that. That's a great question. That is like honestly, it seems to be one of the biggest questions employers have. As I said, you can't ask for documentation, but I have this on one of my slides. Let me see. Basically, if an employee submits a good faith request for HFWA leave, the employer can't retaliate against them. They can deny their leave later if they do discover it, but it's a tricky situation. It's a tricky situation because they can't ask for it, but they can't fire you if you end up being not sick. And fake COVID basically means that you had symptoms, you isolated, you took the leave, and you didn't actually have it. If you had a good faith belief that you did have it, then it's going to be the same thing. It's going to count, and you're not going to get retaliated against. That's a good question. Okay, Antonio, I'm trying to get to your question. Let me find it. Sorry, Antonio, can you put your question in the chat again? I'm having trouble finding the original one.
Nina, this is Tony again. I'm jumping back into the conversation.
Awesome, thank you.
Yeah, no problem. So we do have a couple students here at the CMC campus who signed up to take this presentation as a class through the continuing legal education courses being offered through CMC. I just want to remind everyone on the chat that you are more than welcome to take this class here at CMC on April 20th, where we will be focusing in on on more labor law issues. It looks like we have another question here.
Okay.
From Antonio Rodriguez.
Perfect. I'm happy. Thank you so much, Antonio. Thank you, Tony. Thank you so much, Antonio, for putting that back in the chat. I appreciate it. So you got COVID and you missed a week and your employer is pretending nothing happened. So very typical, situation. And that was a month ago. So what you need to do based on that is I would file a complaint with the Colorado Department of Labor and Employment. And I'm happy to put, if I can find that link and put it in there. But the Colorado Department of Labor and Employment, they understand these issues are happening. So they have kind of a good way of calling attention to those, and they'll investigate that. And then they'll give you a determination, if that makes sense. So I can find that. I can try to find that link and give it to you, but that would be your quickest, easiest, free way of kind of challenging that, because obviously if you had COVID, then you should be able to access that leave.
Natasha, I wanted to ask a follow-up question on the employer an employee situation where an employer, let's say an employee asks an employer that they have, or an employee tells an employer that they have COVID. And under the new act or under the new law, they have to take that as true.
Yeah.
They're not allowed to really question it. What happens if an individual gets COVID, gets time off, and then a month later, 2 months later says, I have COVID again?
Well,
I think
no, that's a great
think,
question.
Go ahead.
Yeah, no, it's a great question. And as someone who has had COVID twice now, it happens. You can get reinfected, and you first have access to that paid leave. And if you use it all up, if you've already used your public health emergency, like the 80 hours, the 2 weeks that you get, and if your employer doesn't have additional ones that they're providing, then you can take unpaid leave. And again, they can't fire you for having COVID and not coming to work. At that point, if you don't have any other leave to use, then you just don't get paid, but your job cannot be in jeopardy, basically. And I know that's easier to say than it is in practice, but those are the rights that are there. So you can submit a complaint if someone's interfering with those rights. It's a process, and obviously it's not going to get resolved in a day, but there are avenues to challenge that kind of thing.
I'm being asked a question here at the CMC class, and really the question is, what right does an employer have in that type of situation?
Well, unfortunately, I represent employees, so I am not super well versed in what employers can do if that's the challenge, because honestly, I mean, that they really have to take it. You can't ask for documentation. So that really, I mean, if these laws for employers might seem really worker friendly, but I mean, it's really kind of past due for it to be worker friendly, especially in a pandemic. And these kinds of leave laws actually, they benefit employers too, so you don't want a super sick workforce. If someone is coming in with COVID, you don't want them to infect everyone. It's better to just keep them at home so they can isolate. So they can't challenge. I mean, they can challenge it and they can fire you, but that action in itself is something that the employee can challenge and say is wrong, which it is. If you're using accrued leave, though, I do want to make sure that we make that distinction again. If you're using accrued HFWA leave, the one that you collect 1 hour every 30 hours, and if you're missing more than 4 days, they can ask for documentation. So remember, that one was a little bit more expansive. It wasn't only COVID, it was also taking care of people that are sick. If school closes down, or other sort of health emergencies. So unfortunately, they can ask for it there, but not if you have COVID.
Thank you, Natasha. While we wait for a few more questions to trickle in here, I wanted to ask you, what happens after February 13th? Let's say that there's no longer a public health emergency in the state of Colorado.
That's a great question, and unfortunately, a lot of people don't know. The issue is that a couple of these laws that I talked about their hook to be able to work and to be something that we can use is that there must be a public health emergency. It can be local, it can be state, it can be federal. There is still a federal public health emergency, and there will be for the foreseeable future. It's not. I would guess for at least a few more months, at least. That's what some people at CDLE are saying. The state one might not be the same, and depending on the law, some of the laws, again, if there's a federal public health emergency, we'll grab that and we'll do that. Some of the other laws, unfortunately, are more of state. So if the state is the same as public health emergency, then we're not going to do it anymore. But there is a website, which seems super strange, but there's a website through the Colorado Department of Labor and Employment, where on that website, it says, like, once the public health emergency is over, we will update this immediately. I check that every day, and there's still a public health emergency. So if I were y'all, I would just, kind of continue to believe that there is going to be one until you hear otherwise, unfortunately. Yeah, I know that that's like a mushy answer, and mushy answers, I mean, law is all about mushy answers, unfortunately, but that's going to be another thing. And then Nina also wanted to tell me, so with respect to retaliation, a bill has been introduced to extend retaliation protections for any workplace health and safety complaints, not just complaints about the formally declared public health emergency. So that would extend the PEW Act and make it more expansive, which would be great. I really hope that bill passes, because that will help, that will kind of like fix that loophole basically that you're talking about. So that's awesome. I hope it passes.
I don't have any more questions at the moment. Natasha, is there anything else that you'd like to say to our participants today?
Yeah, I really want to make sure everyone comes on April 20th. I think, this was a little bit more code specific, and we wanted to get some things out that might, because the public health emergency is supposedly ending soon, we wanted to kind of get those rights out first. But for the April 20th, we're going to talk about wage theft, independent contractors, misclassification, what to do if they're stealing your wages, what kinds of things are wage theft. It's a lot more than just getting shorted on hours. So, we're going to talk about a lot of different things that might be really, really relevant to people. So please come on April 20th or watch the recording. And again, I can't stress this enough. All of our intakes are free and confidential. Please submit your intake and we'll get back to you. It's really important for us to know what's happening, and that way you can at least, it's a free, easy way of being able to have access to an attorney for a little bit at least and get pointed in the right direction.
Great, thank you. I think we have one more question here in the CMC class. Give me 1 second.
Great. Yeah.
And then once that goes away, that
I think that there's a question regarding the public health emergency and the 80 hours that an employer has to pay, and what the difference between the 80 hours are and the 40 hours are, and if those 80 hours go away after the public health emergency ends, and if only the 40 hours stay in place. I hope that makes sense to you, Natasha.
Yeah, no, and that's and what you said is if I understood it correctly, that's what's happening. So for the public health leave, the 80 hours, we are depending on that public health emergency. That is, at least now. If the bill that Nina was referring to passes, then other situations will apply and you'll be able to use it as well. But that's, that will go away, and then you're gonna have HFWA left. So HFWA is gonna be like that, kind of that bedrock that's gonna stay. So you want to make sure that you're still, kind of paying attention to that accrued leave and all of those things. If I understood your question correctly, I'm sorry if I didn't.
was perfect.
Yes, it was great. Thanks.
Great.
All right. Well, I think that we don't have any more questions in the chat or in the Q&A at the moment. So if that is it, I think we will be ending early tonight.
Awesome. Well, everyone can get some time back tonight. But thank you so much for having us. This was great. We always love talking to workers and people who represent workers. So we loved being here, and we're excited for the next one too.
Thank you so much, Natasha and Nina, for being presenters today and being available for the Q&A and the chat. Thank you, Alex and Garfield County Libraries, for hosting and live streaming this event. I want to thank CMC also for hosting the in-person version of today's session. And I hope that we all came out with this with some new information that we can go out there and disseminate into the world.
Thank you. Tony, could you just mention when the next one is for people who might be interested in attending to keep an eye out on it?
Yeah, so this is a series of Know Your Rights events that we're doing in 2022. We have a total